there was more of the traditional spec thinking.
Oh yeah.
So, maybe in whatever, where there's a definite immediate transition.
And they're much more strict about letting you do it. I mean, my next door one neighbour is in an insurance vet. They don't tend to unless their plants let them. Whereas we just sort of do it.
Yeah, well, I know a couple of people in your team were somewhat surprised and Gary.
Yes, exactly. Yeah.
Right, okay, well, I've got to think about this one.
Yeah, the day itself is not really what I imagine is ordinarily.
No, and that's a shame too, because although it's a positive, it's good for them.
Yeah.
Morning.
Good morning.
In retrospect,
Yeah.
It's a week later.
No, it was better if not. Unless you got a letter that hadn't had the ceremony. Yeah.
Morning. How are you? Oh, I'm good.
Yes, Mr. Beard.
My lords, my lady. Today I appear with Mr. Armitage and Miss Proud for the Secretary of State, and Mr. Segan QC appears for Respondents VIP. Just on housekeeping, I think there was some issues in relation to bundles, but I believe you now have 3 bundles, a core, an authorities, and a supplemental bundle.
Yes.
There should be a supplemental skeleton that was also served by the Secretary of State.
Yes.
Needed to
Right. What I've done with it is another matter. I have a nasty feeling I left that behind. Or did I? No? I do myself an injustice. I've got that as well.
That's great. So, with the court's permission, the way I was going to approach the Secretary of State's submissions was in 3 parts. A brief introduction with some references to the previous litigation in relation to this matter. And secondly, I was going to work through some of the key parts of the relevant legislative history and scheme to explain why the Secretary of State's interpretation of the key provisions is correct. And in doing so, I'll focus on the history, the mischief that that's directed at, the wording of the relevant provisions, and indeed its context. And then thirdly, I'll turn to deal with the judgment below and its reasoning, why it's flawed, and in doing so, I'll pick up some of the case law references that Mr. Justice Morris relied upon, 1 or 2 of the other legislative wordings he highlighted, and indeed the passages from previous judgments from, as she then was, Mrs. Justice Rose and Lord Justice Richards.
Do it whichever way you want, Mr. Beard, but at the end of the day, this is a very narrow point of statutory construction. And speaking for myself, but I think also for my lord and my lady, a lot of the rather sophisticated background and surrounding points about the meanings of other provisions is of limited value.
We tend to think that's the case. We're most interested in how the particular provisions came about, why they came about, what the roles were. That
Well, let's get on and do it, but just take that as a...
quite understood.
Such a hint, Mr. Mayor.
Yes, taken. If you will indulge me slightly, though, in relation to the introduction, I think that the court is well aware that this case concerns telecoms equipment known as GSM gateways, and it concerns the question, essentially, whether Parliament intended the statutory scheme that exists under the Communications Act 2003 to permit a requirement to hold a licence before you can use such pieces of equipment because of national security concerns. And I will be focusing on whether or not Parliament could have intended that such a requirement should not be possible.
Well, we'll only know what Parliament intended by seeing what it wrote.
Well, one can see what it's written, obviously, but in order to interpret what is written, we do suggest that some of the context and the structure is necessary.
If it's ambiguous.
If there is any ambiguity.
Okay, but carry on.
Now, you'll have understood, I think, from the outline of the materials that have been set out, that the concern about GSM gateways is the concealment of caller line identity. that gives rise to significant concerns in relation to matters of security. I'm not going to go into those matters in any detail because some of them are sensitive, but I'm sure that the court understands that the way that these devices work is that they essentially allow a landline call to pretend to be a mobile.
Well, putting it shortly, the ones which only have the single use, the COSAG,
Yes.
you can, because it's only a single user, you can track it back in national security terms to the single user's landlines. If you've got multiple users coming into the gateway, as it were, you all that can be identified is the gateway SIM. So you can't identify where the landline calls are coming from. Right?
Yes, and that's precisely right. Essentially, it's creating two problems because in a commercial use gateway, what you'll have is multiple SIM cards in there. Because the landline pretends to be the mobile SIM number, what you can have is a single landline calling repeatedly, but directed through different SIM cards, so it looks like it's coming from...
Well, I think you're just repeating what my lord
yes, I'm just clarifying the other way it works, which is that, so you can have a single person who looks like they're making multiple calls, but you can also have a situation where you've got multiple landline calls, and they look like they're coming from a single number because they happen to be routed through the same mobile SIM in the array.
Well, it's well understood that there are obvious national security reasons why this is a problem.
Yes. Your Lordship will have seen, in particular, at tab 10 of the supplemental bundle, the confidential annex to Mrs. Justice Rose's judgment. The reason it's worth just highlighting this, I'm not going to read it out. I should say it's confidential in a broad sense. Mr. Segan and his clients have, of course, seen this material. The reason I highlight it is because, of course, that case concerned, inter alia, the question whether or not there could be a public security justification for restricting the commercial use of these gateways. And in this annex, there is a consideration by Mrs. Justice Rose of that issue. And if I could just take you in particular to page 5 there. The start is the nature of the public security concern when Mrs. Justice Rose goes through the issue.
So page 5, page 5, what paragraph?
I just want to pick up the heading, in fact. Is the commercial restriction a disproportionate response to the CLI problem? And that is then considered by Mrs. Justice Rose. And she goes on, and just for your notes, there's an assessment of how you carry out the assessment of proportionality in these circumstances, in particular from paragraph 28 onwards. Her conclusion in that regard is at 36. And then she considers some other further arguments that were raised about proportionality. And I just pick up her final conclusions at 72. And the reason I emphasise that is, in this case, there was a full consideration of proportionality. And it was held that putting in place a requirement for prior licensing was proportionate. In other words...
Hang on, sorry, that's not an issue, is it, in this appeal?
Well, it matters because of the way that the judge below dealt with these issues, as I'll come on to deal with in relation to ground 1, because we say that the judge below made a serious mistake in suggesting there was no lacuna in relation to the protection of national security if you could simply have an exemption from licensing with conditions attached. He says no lacuna. And what Lady Justice Rose is saying, Mrs. Justice Rose at the time, was saying was, actually, I have considered that issue specifically, and I have found that putting in place a requirement for prior licensing, in other words, the commercial use restriction, was proportionate. In other words, it was pursuing a legitimate objective. The measures were no more intrusive than was necessary to achieve that objective.
But they weren't. She wasn't dealing specifically with the issue whether what Mr. Justice Morris suggested is practical or not. Isn't that what we're really concerned about? I mean, in one sense, one doesn't get to the lacuna question until one's resolved the construction question, because if the construction question is resolved against the government, for example, then there may very well be a lacuna in the legislation which needs to be dealt with by Parliament. But obviously I'd follow that we are looking at whether there's a lacuna, but whether there's a lacuna depends upon whether, in practical terms, attaching conditions to an exemption is going to work. And I can see there might be problems.
Yes.
But Mrs. Justice Morris didn't deal with that, did she?
She does pick up that, and I'll come back to that issue. But I don't concur with your Lordship's analysis on statutory interpretation entirely, because if it is the case that the arrangements and the interpretation contended for by the respondents and found by Mr. Justice Morris left a lacuna in relation to the protection of national security, it is plainly a relevant consideration in assessing whether or not Parliament would have intended by the words to preclude arrangements that left such a gap in relation to such an important consideration.
No doubt that's right, and that's why Mr. Justice Morris dealt with it. But my Lord's surely right. We first of all look at the words and how the words work.
Well, we certainly
if we take the view that it would be a very strained construction to make them have the meaning you contend for, we've then got to say, well, is the result so nonsensical that we can adopt a strained construction? But it's going the wrong way around to, not that I would have thought to start with the words. That's how Mr. Justice Morris did it. The right way, surely.
Well, as we've set it out in our ground, what we have explained is that given the seriousness of the public interest concern here, and given the fact that Mr. Justice Morris was wrong in relation to the leaving of a lacuna, his approach to reading the statute proceeds on a false basis.
If I may say so, this is what's wrong with introductory remarks. You get ahead of the points that you've got to develop properly. I think we should get on to the issues, and then at that point, if you want to come back to
I certainly will.
The confidential annex in its context, I think then we won't be confusing each other.
Let me move on then to the legislation with the outline about the importance of national security in place. It is worth just working through the relevant statutory provisions. If we may start with authorities bundle at 1B. So here we're dealing with the Wireless Telegraphy Act 1949. This was a version that was in force up until 1995, but all I'm directing the court's attention to is the definition here of wireless telegraphy.
What are you asking us to look at?
I'm just so you have it for further consideration of the relevant provisions. That is the definition of wireless telegraphy.
Okay.
In one.
Yeah, I've already seen this in your study.
Yes.
Yep.
Then if we turn back a tab to 1A, we then have the version of the Wireless Telegraphy Act that was in place between 1996 and 2003. And there you'll see the basic restriction, or under the heading licensing wireless telegraphy. No person shall establish or use any station for wireless telegraphy, or install or use any apparatus for wireless telegraphy, except under the authority of a license in that behalf granted under this section by the Secretary of State, or in relation to a television license, the BBC. And any person who establishes or uses such as any station for wireless telegraphy, or installs or uses apparatus for wireless telegraphy, except under in accordance with such a license, shall be guilty of an offence under this Act. So that is the basic requirement that was laid down in the Wireless Telegraphy Act. In preceding iterations, it had actually been the Postmaster General that had the role of granting licenses, but it became the Secretary of State. And then you have a proviso to 1.1, which says, provided that the Secretary of State may, by regulations, exempt from the provisions of this section the establishment, installation, or use of stations for wireless telegraphy or wireless telegraphy apparatus of such classes or descriptions as may be specified in regulations, either absolutely or subject to terms, provisions, limitations. So there's no issue in this case but that the commercial use GSM gateways fall within the relevant definition of apparatus for wireless telegraphy. Therefore, within the scope of the Wireless Telegraphy Act up until July 2003, the basic provision was that you could not operate such apparatus unless there was an exemption under the proviso without a license.
We've seen all that, yes.
1A is dealing with television receivers, and then you'll see in 2 that even licenses can be granted subject to terms, provisions, and limitations. So that is the basic scheme of the Wireless Telegraphy Act in the run-up to the Communications Act. It's the Secretary of State fulfilling the role of deciding whether or not to license, and is obviously able to take into account a range of considerations that will cover both technical telecoms considerations, but also broader public interests, including national security. If we then move on to tab 2A, we will there see exemption regulations that apply between 1999 and 2003. So these were regulations made by the Secretary of State under the proviso. And if we go on to page 6,
We're saying 2A.
yes, 2A, internal page 6.
We haven't got a 2A, but we've got a 2.
2, then it will be page 6 in the internal numbering. Yeah, I'm going to section regulation 4.
Yep.
So the exemption provides, subject to regulation 5, the establishment, installation, and use of relevant apparatus are hereby exempted from the provisions of section 1.1. So it's a relevant apparatus exemption. But then if you look at 4.2, the exemption in paragraph 1 shall not apply to relevant apparatus which is established, installed, or used to provide or be capable of providing a wireless telephony link between telecoms apparatus or telecom system and a public switch network, by means of which a telecommunication service is provided by way of business to another person. So what you've got is an exemption for relevant apparatus, but not in relation to business use. So this was what was referred to previously as the commercial use restriction. And the relevant apparatus is, you turn back a page, it's in the definitions, and it's defined by reference to schedules 3 to 7 here too. And there are lots and lots of pieces of equipment that are referred to in relation to schedules 3 to 7. I'm not going to work through, but they cover things like, they range from cordless phones right through to some sorts of safe devices and so on. Anything that requires, a whole range of matters that require wireless telegraphy. Now those regulations were in fact replaced by the 2003 regulations, Wireless Telegraphy Exemption Regulations 2003, which in my bundle is at tab 2B.
I haven't got the tab 2B.
Oh.
Wireless Telegraphy Exemption Regulations.
I have them.
Yep.
Yeah.
Goodbye.
And there you'll see, if one turns on to page 6 again within that, you'll just see that exemption effectively replicated with some specific modifications in relation to frequency bands. So those were regulations that were put in place in January 2003, effectively carrying forward the 99 regulations that both contain the commercial use restriction effectively. In other words, there is no exemption from the licensing requirement in relation to commercial use of the equipment. But in 2003, there were 2 major developments in relation to telecommunications law in the UK. The first derived from changes at an EU level. At an EU level, there was the introduction of what's known as the the common regulatory framework. It was essentially a package of measures. We've got some of them in the bundle. For instance, as Authorities tab 3, we have what's called the Authorisation Directive. And at Authorities tab 14, we have the Common Regulatory Framework or Framework Directive. And then
Hang on 1 second.
I'm so sorry.
Yeah.
So what that scheme was intended to do, and I'm summarising, we don't have all the material here, is it was intended to enable better open access across the EU to telecom systems, ensure fair regulation, move towards general authorisation of services and equipment rather than specific licensing regimes. But all of that regime was subject to the ability of member states to act in pursuit of genuine public interests, including in relation to matters of public security and national security. And just to make good that point in very brief terms, if one goes to Authorities tab 14, this is the Framework Directive. And go to page 4. The page numbers are at the top right-hand corner of each page. Page 4.
Page
4. We'll look at recital 7 very briefly. This just summarises the position. The provisions of this directive and the specific directives are without prejudice to the possibility for each member state to take the necessary measures to ensure the protection of its essential security interests, to safeguard public policy and public security, and then it goes on to permit investigation, detection, prosecution of crimes, and so on. Now, that approach is recognised throughout the directives, throughout the scheme, but this was part of a major liberalisation of telecoms across the EU, albeit that the UK was in many ways well ahead of other member states in the development of its law. The second major development that occurred in 2003 was reform of the regulatory infrastructure within the UK, partly driven by these EU changes. The old telecommunications regulator Oftel was abolished, as were other regulators such as the Radio Communications Authority and the Independent Television Commission. And they were replaced by Ofcom, which became telecoms and broadcasting specialist regulator. So the creation of Ofcom and the implementation of the EU scheme were both achieved primarily through the enactment of the Communications Act of 2003. And what we see in that act is Ofcom taking on a whole range of functions, but as I'll show, not taking on functions concerned with the proper assessment of national security in circumstances where it doesn't have knowledge or expertise in relation to these matters. So I'm going to now just turn to the Communications Act itself. The version as enacted is at Authority tab 4. And I'll just pick it up at the beginning, page 20 in the external numbering. You'll see there under the heading Functions of Ofcom, in sections 1 and 2 are general consideration of the creation of Ofcom and its basic role. And then I was going to turn to section 3, the general duties of Ofcom. So these are the general duties in carrying out its functions. And at 1, you'll see it's the principal duty of Ofcom in carrying out their functions to further the interests of the citizens in relation to communications matters further the interests of consumers in relevant markets where appropriate by promoting competition. And then we work our way through a series of more or less specific duties, mostly less specific, but in two, things which, by virtue of subsection 1, Ofcom are required to secure in the carrying out of their functions include optimal use of wireless telegraphy, for example, availability throughout the UK of a wide range of electronic communication services, availability of a wide range of television and radio services. So a whole range of more specific things that Ofcom are required to secure when carrying out their functions. And then in 3, in performing their duties under subsection 1, Ofcom must have regard in all cases to A and B, which are essentially general principles of proper administration, transparency, accountability, proportionality, and so on. And then in 4, Ofcom must also have regard in performing those duties to such of the following as appear to them relevant in the circumstances. Desirability of promoting the fulfilment of public services, desirability of promoting.
Put us in a read out because it's better for us to read it for ourselves.
Yeah, I'm just touching on one or two.
Which one should we be looking at?
What I'm just trying to give you is a sense of the general framework of duties that Ofcom has without going through it.
Isn't it better to us read past our eyes?
Please do.
Presumably, point
No, and it's all telecommunications.
There are subsection 4.
Yes.
J. Things that are concerned return.
Yes, there are. Absolutely. There are undoubtedly vulnerability of children, undoubtedly of public interest, as is the desirability of those are undoubtedly matters that it is asked to also have regard to the extent they consider it relevant in the circumstances. So that's absolutely correct. And it's not entirely surprising in circumstances where it fulfills a broadcasting role, and therefore you're going to take over independent broadcasting commission responsibilities, and therefore those sorts of considerations are going to be relevant. But that's rather different from considerations of national security in relation to how networks operate.
Yes, but from your argument could feed in with the necessity of the direction of the actually
Well, there must be circumstances where vulnerability of children or prevention of crime, or serious crime at least, could cross over with issues of public security and national security. That's absolutely right. But what you don't have here is, notwithstanding the importance of issues of national security that go well beyond these matters, it is worth bearing in mind that all that is being said of Ofcom here is have regard insofar as it's relevant in the circumstances. It's not focusing on
the case is your broader. The Ofcom will simply not be institutionally qualified to make the kinds of judgments that are required.
No, absolutely.
Well, this is all pretty obvious stuff.
I'm
Sorry,
I'm glad it is, and that is a fundamental point of contention. That Ofcom is not qualified to deal with these matters, and they are fundamental interests. And even though there are references to Ofcom touching on matters which might overlap with certain issues in national security concerns, there is plainly not a conflict with national security.
And these in any event are general available to
Absolutely. So then I think it is just worth touching on 5 and subsection 5 and 6. They have been raised elsewhere. Sorry, not 5, 6. I apologise. 6. Where it appears to Ofcom in relation to carrying out any of their functions mentioned in section 4.1, that any of their general duties, so these general duties here, conflict with one or more of their duties under section 4, 24 or 25. Priority must be given to their duties under those sections. And we'll come back to this, this is said to be an example of prioritisation language, and indeed an example of how priority was being given to certain duties under Section 4, which are concerned with community requirements. And I'll come back to explain why those arguments that were relied on by the court are not sound, but I just wanted to touch on.
We don't have 24 and 25. What are they about?
They're actually to do with providing information to the Secretary of State and the European Commission. So presumably the potential interaction there might be to do with concerns relating to privacy and yet the obligation to provide information to the Secretary of State and Commission. We can provide those sections if it's useful.
Well, we've got them in your original authorities bundles where you included the whole act, I think.
Oh, I didn't realise that we.
Well, I've got them. Two of the maroon Chambers bundles.
Right.
And I puzzled as to why I had two bundles which only had 26 tabs in each. One of them was two Lever Arch files worth, and the answer is because the whole.
I apologise for that.
Well, it's been discrimination in favour of my lord there. I haven't had that.
Well, I don't know whether to apologise in relation.
No, I would just move on.
Yes. Section 4, duties for the purpose of fulfilling community obligations. Again, I'm going to touch on this because it's another set of provisions that's relied on when we come to consider the proper interpretation of the language. This section, as you'll see at 4.1, applies to the following functions of Ofcom, and there are a range of functions referred to. The functions under Chapter 1 of Part 2 of this Act, and then they're functions under enactments relating to the management of radio spectrum. And just to be clear, that includes the Wireless Telegraphy Acts. And then there are other matters that are also covered there. And then you'll see in 2, it shall be the duty of Ofcom in carrying out any of those functions to act in accordance with the 6 community requirements, brackets, which give effect, amongst other things, to the requirements of Article 8 of the Framework Directive and are to be read accordingly. So the reason why we'll end up coming back to this is because it uses the language of carrying out and in accordance with. And just for your notes, you then see in the remainder of Section 4 those 6 community requirements that are laid out. So subsection 3 refers to the requirement to promote competition, 4, requirement to secure development of the European internal market, and so on. I won't, again, cast an eye, but I'm not sure that it's necessary to work through all of them in great detail. I will just pick up 11 for your notes, subsection 11, where it appears to Ofcom that any of the community requirements conflict with each other, they must secure that the conflicts resolve in the manner they think best in the circumstances, which is a wonderful piece of drafting.
Yes.
Then we move on to section 5, 5.1. So this is the core provision about which this case is concerned. Section 5, directions in respect of networks and spectrum functions. This section applies to the following functions of Ofcom. They're functions under Part 2, so Part 2 of this Act. And then B, they're functions under the enactments relating to the management of radio spectrum that are not contained in that part. And as I've said, that includes the Wireless Telegraphy Act. And then 2, it shall be the duty of Ofcom to carry out those functions in accordance with such general or specific directions as may be given to them by the Secretary of State. So that's the key provision that has been the subject of interpretive contention. But I'm obviously going to come back and focus on the language of that in due course, but if I could just work through the remainder of section 5. 3, the Secretary of State's power to give directions under this section shall be confined to a power to give directions for one or more of the following purposes. A, which is the one that we've emphasised in this case, is the interests of national security. B, the interests of relations with the government of a country or territory outside the UK. C, for the purpose of securing compliance with international obligations, and D, in the interest of safety of the public or of public health. So there we have a list of 4 absolutely critical public interests. But the Secretary of State's power is confined to only those interests. So whereas under the Wireless Telegraphy Act licensing scheme previously, the Secretary of State had a wide purview of considerations that she could take into account when deciding whether or not exemption was appropriate. Here now, we have a situation where Ofcom is taking on, essentially, the principal role in relation to all technical matters, telecoms-related matters, in relation to whether or not licensing is required or exemption from licensing is appropriate. But Parliament is specifically saying it is the Secretary of State that will deal with these 4 critical issues. But there is no other basis here on which the Secretary of State can intervene and give directions. No other basis set out there. And as I say, those are both critical public interests and ones in relation to which Ofcom simply will not have competence. And I don't mean that in a legal sense, I mean in a practical sense as well as a legal sense. Then we come on to 4. The Secretary of State's not entitled by virtue of any provision of this section to direct Ofcom to suspend or restrict a person's entitlement to provide an electronic communications network or communication service, or a person's entitlement to make available associated facilities. And again, this is very instructive, because what this is saying is that whilst on the face of it, subsection 3, in relation to a narrow ambit of important public interest, the Secretary of State has a broad power in relation to a situation where someone has already been granted an entitlement to operate a service or make available associated facilities. The Secretary of State cannot use those powers to suspend or restrict that entitlement. And as we'll come on to see, there's a separate scheme that deals with that. Now, there are 2 issues that I'll come back to when we're looking at the language here. The first is, it's an indicator of the breadth of the power that you're talking about in relation to subsection 3. And secondly, it's showing that Parliament was carefully looking at the circumstances in which this could be used, including stopping the Secretary of State using that power to suspend an entitlement. In other words, if you're granted an entitlement legitimately and you're operating lawfully, the Secretary of State can't use these powers to take it away. But that provision is needed because otherwise, on the face of it, subsection 3 enables that.
So if the Secretary of State had not given the direction under subsection 3 and the exemption had been granted to
Yes.
the respondent,
Yes.
the Secretary of State could not subsequently have directed Ofcom to suspend the exemption on the grounds of on national security grounds.
Not using this power.
No, not using this power. No.
No, we'll come on to another power that...
No, I understand
Yeah.
that point, but I mean, in a sense, it fits in with your point about lacuna. You certainly couldn't use this. You can only use this subsection before the event rather
Yes,
than after.
absolutely. That is exactly right. And that is how it's specifically structured.
Mm-hmm.
So what we have is key public interest and very close confinement of their use. Directed by Parliament. Indeed, yes. So what we've got here are those 3 specific heads, and what we've what is recognised, of course, is that you can use those powers within 3 to impose conditions on exemptions. That's not a matter of contest. But we say you can't imply a further restriction here using the language, referring to the language of 5.2. You can't imply a further restriction on the Secretary of State's power in relation to subsection 3. And that is, in essence, where the court below went wrong.
Well, let's have a look. Doesn't seem to me to be what Justice Morris's reasoning was, but wait till we get there.
That's the essence of his analysis in relation to carry out and in accordance with, as we'll come on to see. Now, obviously, it's right that there are other provisions I'm going to come on to in relation to these matters.
But isn't it the essence of his analysis that you don't carry out a function by not carrying out a function?
Yeah.
Yeah, that is.
That's not involving implying anything.
You know, everything else is just around the edges. That's the central issue.
Yeah, I mean, that's the way he seeks to put it.
He's
Although some of
right
the way
that,
that some of his reasoning doesn't work in relation to that.
But that's nothing to do. You've seen his whole reasoning. You said depended on implied restriction, but it's not an implied restriction. It's construing the actual words.
Well, what we're saying is that the power in 3 is broadly drawn, and that broad power there shouldn't be limited by reference to the words carry out on in accordance with. He says...
Well, it's the other way around. Subsection 2 is the primary restriction.
Well,
and subsection 3 qualifies that.
Well, subsection 2 is the imposition of the duty on Ofcom, and subsection 3 is the scope of the Secretary of State's power.
That's not quite... Sorry.
So section 2 says, it shall be the duty of
Yes,
Ofcom.
so sorry. Yes, no, I see what you're saying. Okay. Yep.
And so what we say is there's a duty imposed on Ofcom. It has a whole range of functions that it's carrying out, including a licensing function. And the Secretary of State is given here a very broad power in relation to a narrow range of circumstances that have been carefully confined. And what Mr. Justice Morris has done, essentially, is say, because of the references in the identification of the duty to carry out those functions in accordance with, the power that the Secretary of State has is somehow delimited. And we say that's just wrong.
This is something off the point, I know, but before we move from this section,
Yes.
subsections 5 and 6.
Yes, I was going to come on to yes.
Forgive me.
No,
In that
please.
case, yeah.
Subsections 5 and 6. So the Secretary of State must publish the direction under this section in such a manner as appears to him appropriate, bringing it to the attention of relevant persons. Here you're dealing with a situation where, because of the sensitivity of the interests that are at issue, there may be circumstances where you actually have concerns about even publishing the direction and how it is to be delivered. The obligation is to publish the direction as appropriate, and in this case, obviously, it was published. But you'll see in 6, you can actually exclude matters from the direction where actually announcing them to the world or announcing them to particular people would undermine the very goal that you're aimed at. And you can see that you can imagine that there might be situations where someone is operating some kind of telecommunications messaging service that is creating significant problems, and you would want to, or could create significant problems, and you would want that to be stopped by somebody, and you wouldn't want to alert others about it. And there may be circumstances, they would undoubtedly be unusual circumstances, but the provisions in 5 and 6 are a recognition of just how sensitive some of the matters may be in this context, that you actually limit the publication of the direction itself.
And also significantly, you don't just publish the directive to Ofcom.
No, absolutely not. You published it to the world,
But
insofar as possible.
One of the difficulties, I suppose, is practical. Is that I mean, if you're right that the Secretary of State had this power to direct Ofcom not to exempt,
Yeah.
then Ofcom is going to have to say to the the respondent in this case, we are not exempting.
Yeah.
And then the issue arises, well, why are you not exempting us? Because of subsection 5, section 8 requires you, subsection 4 of section 8 requires you to exempt us if we satisfy subsection 5, which we have. So why are you refusing to exempt us?
Yeah.
At that stage, what's Ofcom supposed to say other than because the government's told us not
Well, I
to,
think
as a
that's
consequence of issues of national security?
Well, I think that in practice is what would happen, and I think what 5 and 6 are doing is not remotely precluding that, but they might be precluding what you say as to why in those circumstances.
Yes.
I think the problem is, Mr. Beard, that, and we'll come on to that no doubt when we come to the lacuna, if there's a general exemption, it's not just VIP that's concerned. So it's not just one person being exempted, it's a whole range.
Yes. Yeah.
That's the issue in the lacuna, isn't it? How can you direct Ofcom to exempt VIP if you don't know if VIP are operating or not? It's the unknown unknowns by the general exemption
Yes.
that is contended for.
Yeah, that is the problem with the lacuna. Because if you have in place a licensing regime,
Right.
you will know what is going to be going on, who is doing
And who
what.
you can exempt.
Exactly.
If everybody is able to do it, then how are you going to know who's
This is
doing it and who
precisely
you
the
need to exempt?
Exactly. And this is the difference, which is not properly recognised by Mr. Justice Morris with respect, between putting in place a conditional regime and having the exemption effectively prevented in the interest of national security. And as we'll come on to, what Mr. Justice Morris does is he says, well, there are ways of protecting national security using conditions. And that just does not meet the threshold of national security concerns that we have identified in this case. And of course, we're not just dealing with this case.
And of course, subsection 4 makes it clear, doesn't it? What you can't do, picking up on my lady's point, is after the event, say to Ofcom, right, give us a list of the people to whom you've granted the exemptions, run through that and say, well, you shouldn't have granted an exemption to them, suspend the exemption.
Not using this. I mean, I recognise there are other powers.
Yeah, I understand there are other powers, but if one's just looking at
Yeah,
this
absolutely.
section internally, that's
Yeah.
part of
Well, that's why we
you
say
say
it's
there's a
important.
lacuna.
Yeah, and that's why I quite understand why your lordship wanted to move on to looking at the language, but that is why that lacuna issue I was raising at the start is critical here, because we are dealing with such an important public interest, and that Parliament has taken steps to deal with these matters. And just to lead on, subsection 7, subsection 4 doesn't affect the Secretary of State's powers under section 132.
Yes.
And those are the other powers that would enable certain circumstances, suspension, restriction, and so on.
Well, if you know who you've got to suspend and restrict, that's the point again under section 132. If there's no regulation of the commercial use,
Yes.
then how do you know who's using it? And so it could only be a general restriction that's applied under section 132.
Yes, these are the sorts of problems that arise. No doubt people will say, well, what you could do is put in place an exemption, but then add conditions to the exemption that they had to notify you if they were going to operate the system or some such. But if you start moving in that direction, the difference between maintaining a situation where you need the licensing regime and...
Well, it's the licensing regime under another name.
Well, at that point, we say, well, exactly. In other words, if you can set a series of conditions that effectively require all of the protections that a prior licensing regime would put in place, on what basis can it be sensible to say of Parliament that actually it intended there to be a distinction between the powers that could be operated in relation
Well, I
to
suppose
those?
what you could envisage, I suppose, although I agree with you, it's a pretty cumbersome way of going about it, and it doesn't necessarily address the point my lady's put. Is you could have a situation where the Secretary of State exercises the power under Section 5.2 to direct Ofcom to give it a list of the people to whom it's granted exemptions because it has national security concerns, and then for the Secretary of State to use the power under Section 132 to direct Ofcom to suspend or restrict in relation to particular entities, but that doesn't necessarily address whether simply by having a list of people to whom exemptions have been granted, the Secretary of State has any clue as to whether there are national security issues or not.
Well, there are actually two problems with that. One is, can it identify the national security problems? But going back to my lady's point, if you grant a general exemption, how do you then put a condition in place saying you must tell us, Ofcom, or some mechanism of that sort? You have to put in a system where it says we'll grant a general exemption, except that anyone that's going to take advantage of this exemption must provide prior notification and hit the following. As my lady says, that's just effectively a licensing regime by another name, because it's individualised and it's specific and it attaches a series of prior conditions before you can operate. So the interesting parlour game one can play is how can you construct conditions that get close to a licensing regime and protect national security to the maximum extent without actually having a prior licensing regime? And the answer is, conceptually, you can never win that parlour game because there will always be the possibility of some sort of gap. And the interesting thing, of course, about this case is this isn't a theoretical issue. I can raise this as a theoretical issue for the purposes of interpretation of the statute, but we know here that we've had a court look through and say, actually, the idea of putting in place conditions as an alternative is not sufficient to meet security here.
In any event, we've got to look at the construction, absent facts.
Yeah. I'm sorry. I of course accept, and that's why I make the point as a generalised one. All I'm saying is, it isn't just theoretical. You actually have an example here, which was why I was taking you first to the confidential annex.
Yeah, I'm sorry, I've probably taken you on.
No, I was going to work through those provisions, but your ladyship's points are very helpful. And I should say, even when you've got a licensing requirement, there will be conditions attached to that. And of course, that is actually what this direction does. I won't take you back to it. You've probably looked at it. It's in the core bundle at tab 15. But it says there must be licensing, a prior licensing requirement, and licenses should only be granted when the CLI concerns are met. Sorry, it probably is just worth turning it up. It's at tab 15 in the core bundle. I'll be coming back to the authorities. So core bundle, tab 15.
This is the direction that was actually given, is it?
Yes, this is the direction that is was subject to quashing by Mr. Justice Morris, but obviously subject to interim relief having been granted by Lord Justice Flaux.
Is there any argument that you advance, Mr. Beard, that if anything's at fault, it may be the wording of the directive itself, rather than the statute?
You mean this direction?
Sorry, yes, direction.
No, I'm sorry. Yeah, we don't maintain that we've provided an erroneous direction. We consider that the direction meets the relevant criteria for specifying matters. Your ladyship clearly has something in mind, perhaps, that is...
Well, when we get to the construction of the words used in the statute, there are several ways in which you could say a direction could be given generally or specifically as to the manner in which the duties are to be carried out. And the manner in which that becomes the direction. I mean, some could say that it may be more felicitously expressed than it is.
That proposition, I don't doubt in almost any circumstances with almost any direction, my lady. But I think that the critical thing in relation to the Secretary of State's position is that, as we'll come on to see by reference to what was Section 1 of the Wireless Telegraphy Act, in circumstances where Ofcom, under the proviso, is otherwise required to exempt if certain criteria are hit, we say it is appropriate for the Secretary of State to say, notwithstanding Ofcom's appraisal of its competencies, no directions, no regulations should be issued by Ofcom, and that is effectively what the direction.
Well, I suppose you could have had a direction that they should not exempt from the requirement of a license unless the provider of a commercial multi-use gateway, etc., etc. I think that's the point my lady's got in mind, and that would, at least on one view, that would not be a direction to Ofcom not to carry out its functions, but a direction to Ofcom to carry out its functions in a particular way, in a way in which, at least on one view, this direction is not.
Well, I understand the possibility of an alternative formulation, but if the alternative formulation has the practical effect that you have to have a license in order to, you have to fulfill specific conditions and a general exemption is not available to you, then when we come on to look at 1AA, what it looks like it's doing is, as I think my lady's already indicated, is giving a general exemption, and you would effectively be facing the same argument that you would be stopping the carrying out of the general exemption.
Don't grant a general exemption, only grant a specific exemption in certain circumstances.
Well,
as you say, it doesn't.
Well, at that point,
you're still, in one sense, preventing Ofcom from carrying out its function.
Yes, at that point, it's difficult to see what the difference between a specific exemption from license subject to conditions and a license to operate subject to conditions amounts to in those circumstances. But more particularly, why is it that Parliament would have intended that the power that was conferred should be limited in that way?
I don't think it's in any way detracting from that argument to say that sometimes the text of the direction itself may distract from the statutory construction.
Yes, that's
and
right.
Therefore, I merely ask whether it's any part of your case that perhaps the judge below was distracted by the wording of this particular direction and reading it into the statutory construction, which may have led him astray, as you would say.
Yes. We have not focused on that as being the point at which Mr. Justice Morris was led astray.
Right.
I think would be the
That's
fair way
fine.
of
We
putting
can
it.
leave that then.
Just so that I understand the structure of the direction with which we are concerned is only the first sentence. Isn't that right?
No, I don't think that is correct, my lord.
Still, isn't the second sentence still a direction?
Yes.
Come shall not
Yes,
be
but
maybe it contains
well,
two
I think the
directions.
point I'm getting at, it may well be wrong, is that the Secretary of State wants to do two things. Firstly, he says you can't grant an exemption.
Yes.
Once you've done that, then licensing applies.
Yes.
Then he wants to say, and don't grant a license unless it satisfies these conditions.
Yes.
Now, conceptually, he could have done one without the other. He could have done the former without the latter. He couldn't have done the latter without the former.
I was going to say it's
Yes,
not
exactly. He could have done. It would have been. It wouldn't have been a very useful thing to do because he would then be leaving it up to Ofcom what view they took about these matters.
Well, I think there might have been a broader problem because I think there could have been then a challenge on the basis of proportionality in those circumstances.
Yes.
It would be argued.
I see all that, but nevertheless, functionally, you're doing two things which are separate stages. One is you are taking away to exempt because the conditions under which a duty arises have been satisfied. So you're taking away that. That then enables you to say what should be in the licence.
I understand why your lordship puts it as two stages. I understand that the first part of it is concerned with preventing a general exemption, and the second is to do with the terms of licence. I think it is somewhat dangerous to think of those as two stages, Because
it
they are
depends for
considered
what
conceptually.
purpose. I mean, for some purposes, you've certainly got to take the two together. For example, if you're considering the proportionality of the measure.
Exactly.
But for our purpose in understanding, in terms of the statute, what is going on, it's the first part of the direction that is being objected to. If that part of the direction is intra vires, the second part is unimpeachable and isn't impeached in these proceedings.
Yes, I think. Yes, I would tend to look somewhat in a different way. I think the question one is posing is it theoretically possible simply to issue a direction in terms of the first sentence, circumstances where no licensing regime and no conditions would meet your national security concerns?
Well, but my Lord's point is the second sentence, the second one, it clearly falls within Section 5, Subsection 2.
Yeah.
Because it's a direction by the Secretary of State only to grant license in certain circumstances. And that's clearly
I'm not denying
carrying out its function. I mean, I understand your point that in practice, if you've got a section like Section 8 of the 2006 Act, which requires you to exempt in in a general way, then you don't get to the second point, the second part of it, unless you're right about the first part.
But this is my point. I suppose is we mustn't lose focus. This is a point about the vires. And the vires problem arises only about the first sentence.
Yes, in strict terms, that must be right.
Well, I'm strict.
Yes. In practical terms, that isn't correct, because of course, as soon as you're assessing whether or not you would issue a direction in the terms of the first sentence, you are considering whether or not there are other measures you can take.
Oh, of course. It would be pointless to do one with that. But there's no problem about doing the second stage. The problem is about doing the first stage.
Yeah.
The problem about the technical drafting of the Act, which is what this appeal is about.
And of course, that illustrates a further point in that if and insofar as you want to ensure that there is prior scrutiny, prior notification, prior permission in relation to the sorts of conditions that are set out in A and B, you need to have the vires to do the first stage.
Right, where are we going now?
I was going to go back to the Communications Act 2003, and I was going to be I'm not going to take you through vast parts of Part 2, which deal with network services and spectrum and so on, but I will just pick up Section 45, if I may. Section 45 confers on Ofcom a power to set conditions in relation to entitlement to provide network services. Again, I leave the court to peruse this, but what it does is it enables Ofcom, as you can see from subsection 1, have the power to set conditions under this section binding on persons to whom they're applied in accordance with section 46. And those conditions can relate to how you are going to operate your network and how you are going to provide your telecom service. And section 46 talks about to whom they can apply. And the only reason I identify that is because one of the points that has been touched on against us is this idea that elsewhere in the Communications Act there is a reference to Ofcom having cognizance of national security issues. And one can see that if one turns on to section 94 on external page 88. This is concerned with enforcement of conditions. And so where there's been a notification by Ofcom of a contravention of one of those conditions that's been put in place, Ofcom can take various steps. I'm not going to work through that in any detail. I'll take you on, however, to section 98. Because section 98 is a power to deal with urgent cases. This section applies where Ofcom determined that they're entitled to give a notification under section 94 with respect to a contravention by a person of a condition set under section 45 other than an SMP. So that's a significant market power apparatus condition. So those are special SMP conditions, are where someone's got particular dominance in a market. B, that there are reasonable grounds for suspecting the case is an urgent case, and that the urgency of the case makes it appropriate for Ofcom to take action under this section. So this is essentially short-cutting enforcement mechanisms for breach of conditions. And then subsection 2, a case is an urgent case for the purposes of this section if contravention has resulted in or creates an immediate risk of a serious threat to safety of the public health or to national security. Then B, serious or operational problems for persons who are communications providers or persons who make associated facilities are available, and then serious economic or operational problems for persons who make use of electronic communications networks and so on. So there are a range of specified circumstances that are to be treated as urgent, and one of them is national security. Now, it's somehow suggested, I think, that this means that Ofcom does have competence or knowledge in relation to national security. That is not what this is doing. What it's doing is saying, look, if there is a contravention and any of these issues might arise, then you can act under this urgency procedure. It's an ex post process, so it's not trying to do ex ante analysis of whether or not some system or apparatus gives rise to a national security concern. And more particularly, it doesn't necessarily mean that it would be Ofcom that was actually identifying the national security.
No, I was about to say, I mean, isn't the likely scenario that the government notifies, or the Secretary of State notifies Ofcom that there's a national security concern about the way in which a particular operator is operating its network, at which point Ofcom would use this procedure?
Yes, exactly. Because the reality is, that because of the construction of the Communications Act, Ofcom is the entity that makes regulations, that takes steps to enforce, and is the practical interface with operators. And what is being done through Section 5 and through these sections is ensuring that the entity within government that has the experience can feed into that process. And this is just another example of it. And I'm not going to go through all of the others because there are lots of conditions and there are lots of urgency processes. But that is essentially why national security is referred to here at section 100 and 102, 114, 142, and so on. So any of those references to national security, and indeed in the updated Act in 111A and 139B. So I'm just preempting that objection. And then if I may, I'll just move to 132, which was, as you'll recall, that was referred to in subsection 7 of section 5. And this is the specific power to require suspension or restriction of a provider's entitlement. So this is the specific mechanism that was built in to deal with suspension or restriction. And here you'll see in 132(1), if the Secretary of State has reasonable grounds for believing it's necessary to protect the public from any threat to public safety or public health, or in the interest of national security, then he may give a direction under subsection 3 to the relevant provider, so it's specific rather than general, who provides an electronic communications network or electronic communication service or makes facilities available.
But you say it's specific, I mean, it could be general. Suppose you thought there was a general risk with a particular type of equipment, and that equipment was operated by 100 people, you would simply direct Ofcom to make directions to the 100 people who had licenses
Yes.
to use that equipment.
Of course. What I mean is it's not general in the sense of it being categorised by type of equipment, as we were talking about in terms of exemption.
Yeah.
It can be to many people, but it's still got to be to people. Because, and of course that makes sense in circumstances where these people are already operating. They have an entitlement. That's the predicate of these powers fighting. And I won't go through all of that mechanism, but one can see there
But
that
it requires you to have identified, picking up on a point that maybe mentioned earlier on, it requires you to be able, or requires the government to be able to identify, in relation to a particular provider,
Yeah.
a national security concern.
yes.
And if all you know is you don't like, for national security reasons, these comlinks, then, but you don't know to whom exemptions have been granted generally, that's going to pose a problem.
Well, that's
Well, isn't it, don't even go further than that, the mechanism simply isn't available there
absolutely. If it,
because they don't have well, I suppose they have an entitlement.
They would
They
have
don't have an entitlement under a license. They have an entitlement by virtue of the exemption.
exactly. I mean, that's why we tend to refer to the functions as being the licensing functions. I know that the way that it's put by the respondents and by Mr. Justice Morris is that it's a duty or function to exempt, but actually it's a licensing function, and under the proviso, there's an exemption. But yes, we wouldn't dispute that if someone is properly exempt from licensing, they will have an entitlement. That's consistent with the European law scheme that moved towards general authorisations rather than specific licence. So we have no issue with that definition, but that doesn't solve the difficulties.
But that's a very fair concession. It still feels like a point about licenses, doesn't it, really? So, suspending an entitlement when the entitlement is simply because there has been no requirement for a license in the first place is a rather odd concept.
I understand your Lordship's point in terms of the language, but we're not maintaining that if you're exempt from a license,
No,
you're
I
not
see that.
entitled.
I see
And
that.
therefore, even though it is something of a linguistic contortion, that would be the position.
Yeah.
It's very difficult to know how this direction would be communicated to everyone who was operating in Cornwall without the necessity for a licence. You just couldn't do it, could you? You could take out a public announcement.
But yes,
But
we
apart
don't-
from that, it's identifying who the relevant providers are, which goes back to the point of it's an unknown unknown.
yes, certainly here you would be in Donald Rumsfell's second category. Yes,
So it's
yeah. I think that
not a saving, is it?
no.
Of the absurdity point that Mr. Justice Morris considered.
Well, no.
Sorry to be pedantic, it's a known unknown. You would know.
Yes, it would be. I'm
Yes.
sorry. Yes,
You know there are people out there doing this, but you don't know who they are.
Yes. Sorry.
I always thought Rumsfell was very
category two. I think.
Yeah, I
category
think
one, I
Rumsfell's
agree.
always been very wrongly criticised for that. It's perfectly, what he said makes perfect sense.
Yeah. Yes. I agree. I mean.
Well, I don't. I think it's.
It's possible that they could be both.
Yeah.
You could have a
tactful.
but it is true that you don't know all the activities that might be going on out there, and you can't envisage them all. I mean, that is undoubtedly true. So you.
I mean, if you were looking at it in terms of a national security concern about having discovered that particular components that are being used in systems without identifying anybody,
Yes.
you can imagine who it might be or might not be.
Yes.
That sort of issue,
Yes.
because there you've got in the example, you know who's supplying it, you know what your concern is about that
Yes.
particular supplier, and you could give a direction under this section.
Yes, that's right.
presumably.
Yeah. Okay. I think that must be correct. But it's also possible that at this stage you're unclear about what it is that's creating the difficulty. So you could be. Anyway, I'm not. I think for the purposes of the statutory interpretation issue, whether it's Rumsfell category 1, 2, or
Yeah.
both, doesn't matter.
But my lady's key point, obviously, when you endorse that you can't, in fact, communicate to individuals through the mechanism that would normally be, because you don't know who they are. All you could do would be to make a general announcement. Anyone using
Yeah.
this particular piece of kit must.
Yes, well, I mean, it is of course possible that you put in place some sort of conditionality on the exemption, which would be consistent with Mr. Justice Morris's position that there should be some notification once you are operating, for example. So it's not impossible. I don't want to say that it would be completely impossible to have some sort of de facto list that meant.
So what's the difference then in exempting
Well,
from? Yes.
Yeah.
Yes,
then we're circling back, but
I think maybe giving away too much there.
I'm not. I don't. I hope I'm not.
Licensing by another name.
That's the point I'm making. That if that is the situation, if you could put in place those sorts of arrangements, why on earth would it be that Parliament would have restricted?
My point, perhaps I should have spotted this as we went through, but if Ofcom does grant an exemption under its powers,
Yes.
is it entitled to grant it conditionally? Would it be intra vires for it to say, I exempt, it's not be a general exemption for a particular class,
Yes.
on condition that every member of the class tells us what it's doing?
Well, this is where we're slightly at sea, and it was one of the points I was going to come on to, because of course what Mr. Justice Morris says is it's fine to grant conditions so long as they're in line with or following the direction of
Yeah.
the approach, and we don't actually know what that means in these circumstances.
Well, I'm afraid this always happens. It's our fault. We all do it, of asking you questions before we actually get to your submissions, and indeed before we finish this statutory crawl. So let's get on with this.
Yes.
It's not your fault. It's ours.
No. It's.
But it's how it always happens.
Yes. 132. Let me move on in the interest of time.
That's all we need from this act, isn't it?
The section.
No, I do. I'm so sorry. I do want to pick up. Well, I need to pick up from external page number 140, chapter 2, which is concerned with radio spectrum. So this is chapter 2, part 2. And there, again, what we see is general functions of Ofcom in relation to radio spectrum. I'm not going to rehearse them, the court couldn't see those. And then at 154, duties of Ofcom when carrying out spectrum functions. And I do just need to pick this up. Should be the duty of Ofcom in carrying out their functions under the enactments relating to the management of radio spectrum. Have regard.
Can you give me that reference?
I am so sorry. It's section 154 on external page 142.
Thank you.
And I'm just in subsection 1. 154, it should be the duty of Ofcom in carrying out their functions under the enactments relating to the management of radio spectrum to have regard in particular to the extent to which electromagnetic spectrum is available for use, demand for spectrum, and demand in future. And then there are other duties in 2. And
does this tie in with the points under section 8, subsection 5 of the 2006 Act?
These are those provisions.
So
that they were done here and then they were carried across.
Cramming the band.
Yeah, there are all sorts of issues. Cramming the band, technical interference issues, all sorts of things that occur. But in any event, sorry, your lordship's ahead of me. These are what become the provisions of the Wireless Telegraphy Act 2006. But I wanted to draw your attention to the fact that they were all done here within the structure of the Communications Act 2003. And what you see here are duties of Ofcom when carrying out spectrum functions. And then at the bottom of that page in subsection 4, where it appears to Ofcom that any of their duties under this section, so these general spectrum management issues, conflict with one or more of their duties under sections 3 to 6, priority must be given to their duties under those sections. Now, I took you to 3, 4, and 5. I don't think I took you to section 6. But as you saw, 3 was about general duties, 4 was community obligations, and 5 we focused on. It said against us, well, look, here we have a prioritisation condition. We say, well, yeah, but it doesn't change how you interpret the key provisions of section 5 and what is going on in relation to section 5. And I think it's said at one point that this provision is effectively otiose, if our reading of section 5 is correct. I mean, that's obviously not true, because it's giving priority to a whole range of duties. And it would have been simply bizarre if you'd carved out section 5, 2 and 3 as an exception. So we think that takes people nowhere. So 154, and then if we move on to 156, again, this is a provision we'll see got carried over into the Wireless Telegraphy Act. 1. The Secretary of State may, by order, give general or specific directions to Ofcom about the carrying out by Ofcom of their functions under the enactments relating to the management of the radio spectrum. And then 2, the directions that may be given under this section include. And 3, the directions that may be given under this section include a direction requiring Ofcom to exercise their powers in such cases, such manner. So this rather echoes section 132, but in relation to spectrum functions. And just to be clear, 156 at subsection 4a specifically identifies as being a provision that it can deal with the proviso to section 1 of the Wireless Telegraphy Act, 1949. So I've been referring to it as a proviso, the exemption power, and that is how this statute treats it. And then I just do want to pick up 1565. This section is not to be construed as restricting the power of the Secretary of State under section 5 without the making of an order to give a direction for any of the purposes for the time being specified in subsection 3 of that section. So you have clear language re-emphasising here the importance and difference of section 5 sub 3 being drawn to attention in the context of these directions with respect to radio spectrum. And I will come back to this in a moment and carry it across the Wireless Telegraphy Act. Moving more swiftly on then to page 149, internal numbering. So limitations and exemptions applied to spectrum use is the heading just above 164. And then if we go over the page, what we'll see in 165 is actually an amendment to section 1 of the Wireless Telegraphy Act 1949. And then we see another one at 166. And this is the provision that is relied
Sorry,
upon.
where's the amendment?
I'm so sorry. Do you mean in 165?
Oh, sorry. No, I was still looking at 164.
I apologise.
No, okay, I got it now. 166. Yep.
Well, 165, and then so 165 changes section 1, and then 166 adds section 1AA, exemption from the need for a wireless telegraphy licence. And here we have the key provision that's relied on. If Ofcom is satisfied that the conditions in subsection 2 is satisfied as respects the use of stations or apparatus of any particular description, they shall make regulations under section 1 of this Act, the Wireless Telegraphy Act, exempting the establishment, installation and use of any station or apparatus of that description from the prohibition in that section. That condition is that the use of stations or apparatus of that description is not likely to involve any undue interference with wireless telegraphy. So this is the key provision that Ofcom carried out a review in relation to, following on from the recall litigation, and concluded that it didn't involve any undue interference with wireless telegraphy to operate commercial GSM gateways. And just for your notes in relation to the definition of undue interference, that's at 183. And again, that's by way of an amendment to the Wireless Telegraphy Act. And the definition is whether or not the interference is harmful. So I'm so sorry, it's page 167, external numbering, section
183.
Yes. So there's a modification of undue interference, but that's obviously the definition that applies in relation to 1AA. And I'll just ask you to read that.
And the consultation that was carried out by Ofcom following the recall litigation
Yeah.
follows these provisions.
Yes, yes. Well, actually, it's slightly more than that, as I'll come on to, because there was a further amendment to the Wireless Telegraphy Act that actually added some further, primarily technical considerations.
Yes, but they are mainly technical
Yes,
considerations that we see in that consultation.
Absolutely.
document.
Yeah, yes, and there is no mention of national security or international relations or any
Well,
of
of
that.
course,
sort of
because
thing.
it's not. It's,
Yeah, because it's not the competence. Yes, absolutely. Yes. Sorry, so I think that brings to conclusion my trip through the Communications Act. Just to note, page 178. Those are the general interpretation provisions, if it's relevant for the court. It includes, in particular, on page 179, the definition of enactments relating to management of radio spectrum, just if we join in the dots in relation to what's covered by which provision. If we could then turn on to Authorities, tab 5, and here we see the Wireless Telegraphy Act, section 1, as put in place just after the Communications Act. And all I'm going to just highlight here is this version of section 1 includes those amendments that I referred you to that were brought in by Communications Act section 165.
Do you mean tab 5?
In my bundle, yes. I'm sorry.
Version
Yes,
4 and 6.
Yeah,
Right, okay.
sorry.
Okay.
It's the version from December 2003 to March 2004.
Yes, I'm sorry.
Yeah. So I don't need to take you through that because I've already taken you through the amendments coming out of the Communications Act. If one turns on 2 pages in that tab for the
You
last
say
page,
just after. You mean this came into force seamlessly with the
yes,
coming
it
course?
did. I'm sorry. All I'm doing is I'm actually just referring to
So section 1AA,
yeah 1AA then comes
the
in
last page of tab 5.
exactly.
There's the section as it was in force between July 2003 and February 2007.
Precisely.
Presumably that's when the 2006 Act came into force.
That's exactly right. Yes. Because then if we turn on to the next tab, then we see.
I don't think it matters. I've just lost myself.
I'm so sorry. All I was,
Sorry, what we got at section 1
yes.
is a version which is in force from the 29th of December 2003.
Yes, I actually.
Whereas the section 1AA, 2 pages further on, is from the 25th of July 2003.
Yes. I think for.
I
think
couldn't matter
for
less,
law
but I just want to muddle
purposes,
myself.
The section 1, I think you can probably treat as being in force from the 25th of July 2003. I think there may have been some subsequent modification that meant that immaterially
Yes, I see.
that this was the version that was slightly changed in December. That's all.
We could probably, if we followed through the notes,
Yes.
we could see.
I think the notes do make that clear, but equally, I'm not sure that anything turns on it for these.
No,
purposes.
okay.
I don't think anyone's raised.
No, I don't. The last thing I want to do is make difficulties. I just want to understand it. Yeah. Okay. So we're going to 2006
Yeah.
after last.
Mr. Segan helpfully reminds me there might actually have been a lacuna that the licensing function was with the Secretary of State, but I'm not sure enough about that.
Well, nothing turns on it.
I don't think
unless he
anything
says
turns on
something
it for
does.
these purposes.
Okay.
We then move on to the 2006 Act,
Yes.
and the version that you have at tab 6. Sets out, first of all, general functions of Ofcom in relation to wireless telegraphy matters, section 1. Then, if you move on 3 pages to section 3, the duties of Ofcom when carrying out functions. And here what you'll see is effectively the transposition of section 154 of the Communications Act, which I took you. And the only reason I raise this is because it's these references that are then used in subsequent case law and in Justice Morris's submission, judgment, I'm so sorry. Then if one goes over the page to section 5, you then get the provision on directions of Secretary of State. And as I say, that's effectively the transmission of what was 156 of the Communications Act, which I took you to. And then we get to section 8 of the Wireless Telegraphy Act 2006, which is section 1 and section 1AA effectively fused. Then just to complete on the Wireless Telegraphy Act,
So I just,
I'm so sorry.
I made a note on this when I was pre-reading it. I just make sure I understand it. Yes. Subsection 3 gives Ofcom a power
Yes,
to exempt.
yes,
Subsection 4 converts that into a duty where subsection 5 is satisfied.
yes,
Suppose subsection 5 is not satisfied.
yes.
Are there in fact any circumstances in which it might make an exemption under subsection 3, not as a matter of duty but as a matter of discretion?
I don't see why that is precluded.
I can't.
I don't know what those would be, but
It just seems a rather complicated way of structuring it. If the only intention was that there should be a duty to exempt.
Well, I entirely see that, and I think that's why we've tended to characterise this as the proviso, and we've treated it as primarily a licensing function. But I think that the discretion to exempt is not necessarily excluded for categories of equipment if subsection 5 were not met. It might depend on how it was not met, for example. But I want to be slightly cautious about the extent to which, if you didn't meet section 5, Ofcom could legitimately.
Yes.
Because on one view, subsection 3 is completely odious. Because if you went straight from 1 and 2 to 4, and you just said if Ofcom satisfied the condition in 5 is satisfied, they must make regulations exempting the establishment, etc.
Well, it might be, but there might be other considerations in play in relation to equipment. I'm just loath to.
Well, it may be
accept
that it's dealing with for example, the point that the exemption can neither be absolute or subject to terms, provisions, and limitations as specified.
Well, there's that, but there may also be circumstances where either equipment or arrangements are such that the concerns in relation to undue interference don't arise in quite the same way.
I suppose, picking up on that point, because one of the aspects of undue interference is, for example, interference with navigation.
Yes.
So you could grant an exemption, but and this is going to show my ignorance of all these things really. You could grant an exemption on condition that the system didn't operate within 20 miles of a port or something like that.
I suppose that might be an example.
Just
yes, it's an interesting suggestion. Certainly from a legal point of view, it's not our case that subsection 3 is effectively empty.
No. Well, I mean,
and I don't think that would be right for us to.
I can't think the draftsman intended it to be.
No.
It was just a puzzle, though, for me looking through it.
I understand that, given the
But it doesn't ultimately matter because we are dealing with a situation where the power is a duty, i.e. with the subsection 4 situation.
Yes.
That's what creates the problem for you.
Yeah.
Yeah.
I think that's undoubtedly right. I think what it does illustrate is that although what has been done here is saying, well, when that threshold is hit, you must give an exemption, it's actually part of a proviso scheme in relation to licensing, and therefore it isn't a strain in relation to the language of carrying out in accordance with, that you're carrying out your licensing function in accordance with the directions of the Secretary of State, if you want to look at it linguistically. If I may, I'm just going to move on to, I'm sorry, no. No, I thought there was a further question. I was just going to move on to the Wireless Telegraphy Act 2006 as amended, because this just picks up and clarifies the position that I was mentioning in response to my lady's question about the considerations in the Ofcom consultation. So here we have the amended Section 8.
Reference?
This is tab.
Tab 8, I'm so sorry.
Tab 8.
Tab 8. And I think for our purposes, the principal amendment here is in relation to subsection 5, because as we were just considering, that focused on undue interference with telegraphy, wireless telegraphy as being the only condition. But now we have a situation where the conditions that mean there shall be, as your Lordship puts it, a duty under or to issue regulations are that it's not likely to involve undue interference with wireless telegraphy, or it's not going to have an adverse effect on technical quality of service, lead to inefficient use, endanger safety of life, prejudice the promotion of social, regional, territorial cohesion, or prejudice the promotion cultural, linguistic diversity and media pluralism. So again, all matters within the scope of Ofcom's competence. I mean, even the endanger safety to life. I mean, what we're talking about is there other electrocution risks and so on.
Well, yes, that's exactly how they read it in the consultation.
Yes, and those sorts of issues, which obviously, as a technical authority, looking at pieces of kit and how telecommunications substations work and so on, they're very well qualified to look at. But obviously the striking thing here is, understandably, there is no reference to those key public interests of national security or international relations, because they fall entirely outside Ofcom's purview. So what's being said here is, you can look at these range of issues, and you can say that we're not going to grant a blanket exemption, a general exemption, because we're concerned about the prejudice, the promotion of cultural and linguistic diversity, which may be a perfectly good and legitimate concern. So you can stop an exemption being granted on that basis. But the case that's being put against us is that Parliament intended that you couldn't stop an exemption on the basis of national security. And with respect, as soon as you look at those sorts of criteria, the plausibility of the account that's put forward by the respondents and the conclusion reached by Mr. Justice Morris is just obviously wrong. The idea that Parliament intended that you could stop exemptions on the basis of these criteria, but not on the basis of national security.
Yeah. We can cut to the chase here. Subject to anything that Mr. Segan may say, the idea that Parliament intended that is hard to understand.
Yes.
Problem is, it may have made a mistake in its drafting. Didn't actually provide for what it intended, if you like.
Well, we say...
Or just lazy drafting. That you know, they could have included a subsection in Section 8 that made it absolutely clear that it was subject to the power or the right of the Secretary of State to give directions under Section 5 of the Communications Act. And we wouldn't be sitting here today.
Well, I'm certainly, it's part of the submissions of the Secretary of State that, having been through this process and being before this court, that there isn't the possibility that drafting could be clearer. That is obviously not part of the Secretary of State's submission. But I think if one takes the history that the Secretary of State had the power to prevent blanket exemptions prior to the Communications Act, and indeed, as we will come on to see, the exemption arrangements were precluded, the commercial restriction stayed in place up until the Ofcom review, even after the advent of the Communications Act. So history, differential rules, the mischief of what is being dealt with here, serious public interest, no reason why Parliament would want that wording to be read other than enabling national security properly to be protected. But I think it's also worth emphasising in relation to the wording, and I'll come back to these points in a moment when I deal with the judgment, but functions that issue a licensing functions, they must be carried out in accordance with the Secretary of State's directions. When you put the proposition like that, there isn't anything wrong with that. Now, it's recognised that the introduction of the amendment under Section 166 of the Communications Act, which has given rise to these concerns, in amending the proviso, undoubtedly has caused a degree of confusion. We accept that that has happened. But when one looks at the history, the mischief that's aimed at, the context in which this is to be seen, the other provisions that I've referred you to, including those that specifically refer to the importance of the Section 5.3 powers, that in those circumstances, it is clear that carrying out functions in accordance with the directions of the Secretary of State include carrying out those licensing functions without granting a generalised exemption where Ofcom, dealing with its competencies, has decided that the criteria that it can consider are met for a generalised exemption. And the fact that Ofcom is the body that then is the regulation maker under the structure doesn't change that. We have essentially two bodies, one which has a very narrow set of competencies, the Secretary of State in relation to particular public interests. It can ensure that those regulations. So, if I may, I'll move on to the judgments and the specific errors in it. Now, I'm conscious of your Lordship's admonition at the start, focus on the language. I hope by working through the statutory scheme I have done. I was going to take the judgment errors.
Well, we'll trust you, Mr. Beard, but at some point you have got to look at the actual wording. But it may well be that the judgment is a
yes. I was going to do that.
It's a vehicle for doing that.
Yes, and I was going to do it in order of grounds that we've set out in our skeleton.
Enormous. It's several ways of saying the same thing, isn't it?
Well, yeah. It may well be. It may well be, and that may be a criticism of the way in which we presented it. But on the other hand, we think that the judge has looked at a series of issues and misconstrued.
Okay. Well, let's not argue about it. But I do want. It's all rather indirect, looking at it the way the judge did it. Ultimately, this is a point of construction. We look at it for ourselves and decide what we think it means.
Yes.
It's not. This isn't a. This is. There's a right construction and a wrong construction. It's still obviously helpful to the judge's reasoning, but it's not a case where we have to find a flaw in the judge's reasoning.
No. Okay.
But still, as long as you're going to do it, I don't mind how
I certainly am. We deal with the language under ground 4 of our ground, so I was going to take them in order.
Do whatever way you want. But
so, if I may, I'll pick it up with ground 1 in our grounds, which deals with the lacuna points. I can dispose of it relatively quickly, I think. If one has the judgment, it's in tab 7 of the core bundle. And turn to external page number 90. You'll see there that at paragraph 66 and 67, the judge there looks at the division of functions and the fact that the Secretary of State has retained responsibilities. He says in the main, we say has retained responsibilities for national security matters. Public safety and public health, we note the other considerations. But 67, however, that consideration of the separate competencies doesn't conclusively point towards the Secretary of State's construction. as explained below, there are other mechanisms open to the Secretary of State to exercise his powers to safeguard national security and other public interests. Well, that then takes us forward in his judgment to paragraph 18 and his direct consideration of whether or not there is a lacuna. And if we could just work through briefly these paragraphs. He is essentially saying you can protect national security without a prior licensing regime. And he says in 81 in terms that it doesn't create a lacuna, his interpretation. And he's first, there are other ways for the Secretary of State to safeguard national security risk by preventing exemption of COMUGs. They could direct Ofcom to impose in regulations conditions or limitations on the use. They could be precisely the same as those in the second part of the direction. No reason why Parliament shouldn't choose to address issues of national security in this way. And he then recognises in 82 such measures are not precisely the same as a system of full ex-ante regulation. Nevertheless, they do allow the Secretary of State to protect matters of national security and don't leave the Secretary of State unable to take measures to protect those interests. This doesn't create such a lacuna in the Secretary of State's powers. Now, with respect to the judge, there is no basis on which he could make that finding.
What do you mean?
He does not know whether or not interests of national security can adequately be protected in all circumstances by the operation of a generalised exemption and then the imposition of conditions. He just doesn't know that.
Well, he knows there is a mechanism.
He knows
He's allowed to draw conclusions about what mechanisms.
Of course he's entitled to.
He's not saying, and he can't say that that will work as well.
He's saying it's another way of doing it that may.
Well, yes, but he says there's no lacuna. That's what he's saying.
Well, no, I think all he means by that is this isn't a case where there is no mechanism. He is not saying, and if he were, I would quite agree with you, I know that that mechanism is just as good.
Well, with respect, if someone says there is no lacuna, that is saying there is no gap between the proper protection of the interests under one mechanism or the
Well,
other.
I don't think that is what he's saying, but if that is what he's saying, then your point is obviously a good one.
And I think that there is no other meaning that can be attributed to the term lacuna in those circumstances.
Well, I think there is, but anyway, let's not argue that.
But there is undoubtedly a gap there, and it's the gap we've been traversing, and the conditions mechanism doesn't deal with that. And of course, this is a case, as I've already adverted, where in fact we have the consideration by the previous court in recall that has assessed this issue and has recognised that conditions wouldn't be sufficient. So it's particularly odd for the judge to have said here there is no lacuna in circumstances where if there were no lacuna, the assessment of proportionality that had been carried out by Mrs. Justice Rose would not appear to be consistent with that. And
in actual fact, if all you're saying is you could impose a condition which was the same as the second part of the direction. And as I understand how these co-modes work, that would be exactly the same as saying you don't have an exemption.
Well,
in real terms.
Yes, we'd be back in.
Because what the direction, the second part of the direction says you shouldn't grant an exemption. You shouldn't issue a license unless the COMUG enables you to identify the source of the cause, which of course by definition it doesn't.
Yeah.
So you're actually what you're doing is really bringing in by the back door what on the judge's construction you're not allowed to do what it
The only way he avoids the lacuna is by putting himself essentially on the problem of walking before, by saying essentially this is like a license, because otherwise he can't reach.
But is that why is that obviously wrong?
Why is it obviously wrong? I'm sorry,
To do what he's doing here. To
well,
say you can do by another route, you can impose as a condition of the exemption what you would otherwise do as a condition of the license.
because he's using that as a basis for saying that the power and an interpretation of the statute should be read as limited. In other words, he's saying, because you can do something using other tools, the conditions, that means you should essentially read carry out in accordance with as constraining the power that the Secretary of State
You
may
see, I don't think
exercise.
he saw it that way, and I'm not sure I do. I think he said, look, I think he saw it, the natural meaning of the words is that you can't impose a condition to prevent you carrying out a function in the first place, and a fortiori where that function is a duty.
Well,
And therefore, he says, if he doesn't say this, I'm putting it to you, the role of the lacuna point is really to say, but if that is right, the result would be crazy if it meant that the Secretary of State had no weapons to protect important national security interests.
or insufficient weapons, yeah.
Well, there's a limit to which the court can be a judge of whether they're sufficient or not. What he can say, however, is that the Secretary of State did provide himself with tools, C 80 to 83, which enabled him to achieve, to take steps to protect national interest by a different route.
Yeah.
If those are less good than the ones that he could have done by saying that you can tell them not to have exemption regulation in the first place, well, that's his problem because he hasn't legislated effectively to achieve what he wants. But it is not a lacuna in the same sense as there being no tools available to him at all, which is a result that I should strain the words to avoid. Sorry, I put that rather clunkily.
No,
but
no,
you see
the point is, that, not in any way, the point your Lordship makes that there are tools there, and that since there are tools there, one shouldn't suggest that there's some kind of shortfall in the levels of protection of such a magnitude as mean that the relevant provisions should be read as permitting the Secretary of State to have the power to prevent a general exemption. And I understand that is one way of interpreting what he's saying, or an alternative argument, it doesn't matter.
Yes.
But the point I make is that in relation to a serious concern in relation to national security, the fact that a condition imposition mechanism after a generalised exemption would give rise and could give rise to concerns about the proper protection of national security is in and itself a lacuna and a good reason why Section 5...
The problem is it's a smaller lacuna, and it's one which the court really isn't in a position to assess. We can't say this kind of power is essential, that kind of power is suboptimal, and with something as important as national security,
well,
you must always have the optimal power.
Well,
you've got to say, well, that Parliament will have judged how to what checks and balances to put in, and
well, agreed, and it's up to a point, because the point I make is that in relation to national security, there is no reason to consider that you should read the provisions as meaning that Parliament would have intended a suboptimal protection of national security. And as I say, the position is particularly ironic in this case, where you have a finding of a court that is effectively saying, if you were to use the condition mechanism, that would be a suboptimal.
You're talking about Mr. Justice Rhodes.
I am, yeah.
But can we just look at paragraph 81?
Yes.
And I'm sorry it's going to sound like a broken record, but doesn't this take us back to the wording of the directive? The judge in section 81, it says, the Secretary of State could direct Ofcom under section 5.2 to impose in regulations made under section 8, subsection 3, conditions or limitations upon the exemption from the requirement for a licence.
Mm.
So, if the direction had been, I direct that before you exempt, you must A, B and C, rather than I direct that you must not.
Yes.
It's just it's a different expression, but it's carrying out the direction.
Well, yeah. There are obviously two issues there. One is, why would Parliament have intended to constrain? We've been across that. But there is the argument that I would anticipate that will be raised against that, which is Section 1AA, and which became Section 8, is about giving a general direction, a general exemption, whereas what would be being envisaged there would essentially be undermining the general exemption.
Well, the judge is suggesting that you do.
Well,
that you've got the facility to. So
yes.
he wants his cake and eat it.
Well, he does undoubtedly, because when we go back to his analysis of language and where he highlights the idea of any conditions being permissible when they are in line with or in the direction of, we simply don't understand what that means in this context. We don't understand how, if he's envisaging that you could put in place conditions that would effectively leave no lacuna or no material lacuna, on what basis does that end up being in line with or in the direction of the
exemption? Yeah, right.
So there is an incoherence in his judgment.
Well, I'm being slow. So I'll go, my lord
No,
go
no,
first.
you
My
go.
lord can go first.
Well, what I was going to say was that if by the second part of the direction he means effectively the second sentence in A and B,
Yeah.
this is not. It's not precisely the same, because that second sentence says Ofcom shall not issue a licence unless A and B.
Yes.
What this is postulating is circumstances in which you would grant an exemption.
Yes.
So actually, this is internally inconsistent.
Well, I think on that technical basis, you're absolutely right, my lord. I envisage that and obviously I'm speculating somewhat because of the point your lordship makes, but that he is envisaging much more the position that Milady was putting forward, that you would essentially modify the second sentence of the direction to turn it into a specific exemption if you...
Specific exemption if you do A and B.
But at that point, the difference between saying you must have a licence and you are exempt from a licence...
But then why is that a good point for you? Isn't it a good point for the other side? Say, look, there's two ways of doing the same thing.
Well, you could have done it the other way, which wouldn't have fallen foul of
Well,
some section.
we say, on what basis would you delimit the powers in those circumstances to prevent the straightforward approach? Why would Parliament ever have intended that?
Well,
but
why wouldn't it have been? If there's two ways of doing it, and the wording clearly points to the judge's way of protecting national security, why shouldn't we be content with that?
Because, A, the judge doesn't know for the reasons we've articulated, but second of all, we get into this problem that what you're talking about is a general exemption being provided for in Section 8, and then you're saying, actually, it's not going to be a general exemption at all. It's going to be
Section 8 doesn't actually use the word general, does it?
It doesn't use the
It
word...
uses the words... Can we just look at it?
Yes, of course. It's the type of apparatus that...
Yeah, well, exactly. So what the regulations would say, of the type the judge envisaged, is the use... the installation or use of commugs is exempted from the requirement for a licence under subsection 1 on condition that, that's picking up the word subject to such limitations, on condition that A and B.
Well, and possibly...
Why doesn't that work?
You might have other conditions that may be imposed.
No, right, but I'm just trying to...
What's the answer to my question? Why doesn't that work? Why does that say you shall not grant an exemption except on the following conditions? So you don't get into the problem about are they carrying out functions or not carrying out functions, because they're clearly carrying out functions, but the Secretary of State is saying in carrying out those functions you must impose the following conditions to any exemption. The terms of the... Well,
first of all, I make the point that what you are effectively doing if you go down that course is putting in place a default licensing regime.
Yeah, but so what?
Because there is no reason why Parliament would have intended there to be a difference between the power to deal with this directly and say, look, there's a licensing scheme, let's make sure we use the licensing scheme. There is no reason why you would want to contort yourself into using an exemption.
Well, Parliament sometimes doesn't do things in the most elegant way. You have a good point if the system wouldn't work from a national security point of view, and you can demonstrate that it couldn't work, then you're in business. But just to say it's clunkier than doing it another way doesn't matter if it's what Parliament provided for and it gets to the same place.
As I say, in relation to this case, I do have the position that say it doesn't work, because that's what Lady Justice Rose found. She said...
Well, you may have to show us that again. That's the problem with showing us all that at the very beginning.
Well, I'm very happy to come back to it. But can we just go back to the terms of the exemption? So, obviously, in 8, Wireless Telegraphy Act 2006, 8.3, as your Lordship says, you've got Ofcom has a discretion, may, by regulations, exempt installation, use of wireless telegraphy stations or telegraphy apparatus of such classes or descriptions as may be specified.
So can we say comargs?
Yes.
Yeah.
Ofcom may not make regulations under 3 specifying terms, provisions, limitations. Sorry, that's 3A, apologies. And then 4, if Ofcom is satisfied that the conditions filed are satisfied in respect of the use of stations or apparatus of a particular description, they must make regulations under the subsection exempting the establishment, installation and use of a station or apparatus.
Say the apparatus is comargs.
So you're talking about the type of apparatus here.
But what's the problem?
Because what you would be doing with a licensing regime is making sure that an individual had to hold a particular license in order to be able to operate the piece of kit consistent with the relevant directions. What your Lordship seems to be positing is the idea that the conditions in the direction to exemption would not only talk about
conditions in the exemption.
Yes, sorry, you're talking about, I think, attaching conditions to a putative exemption.
Yes.
Would say you're exempt if you do this and you can show it. Because if you aren't in the territory and you can show it, then there is a gap between a prior licensing regime and an exemption, at which point the judge is conceptually not right that the conditions do the same thing, even if...
Well, they do the same thing, but they do it less well, because if you have to apply for a license, then they keep a list at Ofcom. These are all the people who have licenses, subject to these conditions.
Yeah.
If it works by the exemption, and this is my lady's point, I think, you don't know. All that happens is if you find someone using a comarg and not able to satisfy the conditions, you come after them and say you're breaking the law, and they say, no, we're exempt. And you say, no, you're not exempt. Look at the conditions on the exemption. So, sorry, this may be all you're saying, but I just wanted to pin it down. It's important. The distinction between the two regimes is that in the one case, Ofcom knows who has a license.
Yeah.
In the judge's alternative, Ofcom doesn't know, although if it finds anyone doing it, it can come after them.
Yes.
Is that a key point?
Well, that is certainly a key distinction between a licensing regime and an exemption regime. And
Yes, okay. I'm sorry if I'm being slow, but there's no harm in
absolutely.
pinning these things down.
Yeah.
And that I understand, she will say if I'm right, is the point that my lady was making to you much earlier.
Yes.
But is there, okay, that's one difference in practice. What other differences are there?
Sorry, I was engaging not only with that issue, but also the practical point that what you have here in Section 8 is a generalised exemption for a type of equipment, and it is not personal, the exemption. What would have to be created in order to have the similar sorts of protection would be effectively distinctly personalised exemption.
That's what I'm not understanding.
picking up on my lord's point about, well, it's really my lady's point about, you wouldn't know who's exempt.
Yeah.
The only way in which you could deal with that, I suppose, is by saying, in the exemption regulations, you'll be entitled to an exemption if you demonstrate to our satisfaction these two things.
Yes.
Yeah.
And all that is just a system of licensing by another name.
And that's all I'm saying. The reason it goes to support us is
But so demonstrate, just spell that out. To demonstrate means you've actually got to write into us. So I'm not applying for a license. I'm just telling you, look, here's how I'm operating my kit.
well,
I'm trying to see what demonstrate means in
it would
actual
have to
practical
be,
terms.
It would have to be demonstrate to the satisfaction of the Secretary of State, because otherwise you've got a lacuna. There's no...
Also a demonstration of satisfaction of Ofcom.
No, well, it would formally be to the satisfaction of Ofcom, but in
Right.
relation to these matters, I think that the issue would arise that the expertise lay with the Secretary of State and attendant relevant agencies. So it's not going, it would be through the means of Ofcom.
Okay, well, suppose that, whereas you're right about that,
Yes.
so the exemption wouldn't just have to say on condition that your COMAG will allow us to get the information we want under A and B. But the condition actually says that you write into us, telling us you're doing this, and saying that your equipment does do this, right? That's what it would. You say that is what.
You'd have to show, I think, that you were able to do this in order to...
Well, isn't that what I just put to you?
Yeah.
So you're not entitled to an exemption unless you write into us with this information about A and B and satisfy us or the Secretary of State that you can comply with those conditions.
Yes. And therefore you're
That's-
turning the situation into
That's
personalised and effectively...
Yeah, okay. I see exactly how you're putting it. Now, suppose that was the condition,
Yeah.
that it said all of that,
Yeah.
then the difference would be insubstantial between the two. You would say it would just be a licensing regime by another name.
Yeah.
Okay? Now, whether or not that was what the judge specifically had in mind, suppose it's what I had in mind.
Yeah.
Why isn't that something that the Act could provide for without telling them that they must issue a blanket exemption?
Well,
Sorry, I mean the opposite, that they may not issue an exemption in the first place.
well, I think it's necessary to take a step back and see why we're here. The argument is, it would not be carrying out, in accordance with the direction, functions of Ofcom to effectively put in place a scheme that means that the general exemption of apparatus, which is, as it's put, a duty under Section 8(4), is permissible. In other words, you would be achieving by that means, if you enable rearrangement of the exemption scheme so that you have prior notification, the ability to have prior testing and compliance with all of the conditions, you are in those circumstances doing what is in effect a licensing regime. If that is the case and that is permissible, on what basis does one interpret, not carry out in accordance with, as expressing a meaningful difference between that outcome and preventing the license?
Well, the difference is between doing what the Act of Parliament says you can do and not doing what the Act of Parliament, doing something the Act of Parliament says you can't do. It is, you might say, technical. It means we're arguing about something you could put right at the stroke of a pen. But because of the rule of law, it's quite important you do it the right way.
Well, I don't think any of us are disputing the importance of the rule of law here. Indeed,
No, but all right. But okay, perhaps I was adding, I was being provocative putting it that way. But if Parliament says, and I know you say this isn't what it says, if Parliament says you do not have power to prevent an exemption being issued where subsection 5 is issued. Then we must respect that, and we can be comfortable in respecting it because you can still achieve national security objectives in another way by directing the Ofcom, when issuing its exemption, making its exemption regulations, to impose conditions that will do the same thing effectively as a licensing regime would have done.
But as I say, it's difficult to understand why Parliament would have permitted the achievement of the same objective by means of the language of carrying out in accordance with the
Well,
directive.
I see that, but if the language is sufficiently clear, we've got to respect it. Whether we think that's rather silly, they could have done it a different way.
Well, we say that
It's clearly
obviously
carrying out its functions. In my Lord's example, Ofcom clearly is carrying out its functions, isn't it? It's carrying out the function of granting an exemption pursuant to Section 8, but it's imposing conditions on the granting of an exemption,
well,
which subsection 3 of Section 8 clearly entitles it to do. And I mean, we haven't looked at 3b, which does say what that they must be objectively justifiable and not such as to discriminate unduly, etc., etc. And that second one, 3b sub b, does suggest that one's looking potentially at general conditions that are imposed on a class of operators and not just on
well, yes.
individual
I think the bigger problem may well be, the challenge could be raised, that the exemption provision that is provided for in 4 is about the equipment and not the individual. And that's why the 3BB provision is...
Well, hang on, it's always about individuals in the end, because what is unlawful is installing or using equipment.
Well, the enforcement is, but with respect, my Lord, that isn't the way in which the exemption provision is drafted. The exemption provision is if Ofcom are satisfied as respects the use of stations or apparatus of a particular description, they must make the regulations exempting the establishment, installation and use of the station of...
No, is that right? No, I don't think that's quite right. It's exempting the establishment from subsection 1.
Yes.
And subsection 3 is more helpful on that. It makes it clear. Made by regulations exempt from subsection 1. And subsection 1 is about making it unlawful to install or use.
Yes.
So ultimately, however the 3 or 4 may be worded, it is a person being exempted, not equipment.
But with that, I'm not sure. I think the person may benefit from the exemption of the equipment is technically the way in which that provision is structured.
But surely, if you just go back to 8.1,
Yes.
license, which is the license, just forget everything else.
Yeah.
License requirements. It's unlawful to establish or use a wireless telegraphy station or to install or use wireless telegraphy apparatus, except under and accordance with the license. That's clearly directed at either individuals or corporate entities.
Yes, absolutely. But that's licensing. That's the point about it. Yeah.
Because then 3, made by regulations exempt from subsection 1.
Yes.
And
Is that
sorry,
installation
yes,
and use
exactly.
of wireless telegraphy?
Well,
That again is directed at individuals or corporate entities.
Yes, that is absolutely true. But it's then when we come on to the generalised exemption, which is the provision that creates the difficulty. The point I'm making there, that what that does is it seeks to put in place an exemption in relation to a type of apparatus, because that's why it is put in terms of a generalised exemption. Now, you may well say that what that means is that for everyone that is using that type of equipment, they are exempt from a particular licence.
I don't see how that helps you with respect, because that doesn't highlight the limitations, the terms, conditions, or the term provisions or limitations which the Ofcom can impose under subsection 3 will relate to matters other than subsection 5. So they will relate, for example, to issues concerned with national security.
Well, certainly the conditions that can be imposed won't relate to subsection 5, because subsection 5 is a predicate.
Because if you didn't satisfy that,
then you wouldn't be there. So I think even if that language wasn't there, that wouldn't make any difference. The concern that I'm articulating is that in order to get to the point that this court is contemplating, which is essentially saying, well, you can condition and personalise the exemption to such an extent that it has absolutely the same effect as a prior licensing restriction, A, doesn't fit with what Parliament had intended, but B, it will be said against that it is not consistent with the structure and force and purpose of the generalised exemption that is put in place in 1AA, which creates the problem in the first place. And that is the residual concern in relation to these matters. After all, the judge below said you can only put in place arrangements that are in line with or in the direction of the carrying out of the function. If what this court is contemplating is a structure of conditions that go as far as achieving the same levels of national security protection as would a prior licensing regime, it is difficult to understand how the reasoning of the judge at all fits with that. Now, of course, this court isn't bound by the reasoning of the judge, but the reason the judge went in that direction was he was saying, well, what does that term carrying out in accordance mean? It must mean that you can only much as is consonant in the direction of the other functions. Your lordships and your ladyship are exploring the possibility of provisions that would clearly cut across that approach, because if one was to reach the point of saying that you're achieving the same effect as with a license, it is difficult to understand how that is inconsistent with the reading of carrying out in accordance with, because if a license requirement is not carrying out in accordance with, why is a set of conditions that achieve the same as a license consistent with carrying out in accordance with?
Can I? It's a point that my Lord made, and my Lord Justice Underhill made some time ago. It is quite difficult to see how you can condition an exemption. It's either an exemption or it's not.
Yeah.
And if one looks at subsection 5, it is talking about an exemption. And of course, it's not Ofcom that can then make conditions of the exemption, it's the Secretary of State.
Yes.
But we then get to the position of saying, how can those exemptions be confined or restricted without raising the same ultra vires point that is made against you now,
Yes.
which then goes to show that we're back into the territory of who looks after national security.
Exactly. Yes.
So, looking at the judgment again, if we may,
Yes, please.
the judge below refers to section 8.3. Is that a typographical error?
Sorry.
In paragraph 81, the Secretary of State could direct Ofcom to impose in regulations made under section 8.3, and we're talking about 8.5, aren't we, an exemption?
No, I think it is 8.3.
No,
Is it 8.3?
I think he's referring there to the discretion to.
So the power rather than the function,
So power rather
which
than
again my Lord investigated with me.
Yeah.
So section 8.3, all of the conditions under section 8.5 are not made out,
Yeah.
but we can make these provisions
Yeah.
under section 8.3. If we get to 8.5, are we to read it that he's recognising, the judge is recognising here that you can't make a condition of an exemption?
I don't know that one can go that far. I mean, he's referenced.
But if you can't, this meets your point, doesn't
Yeah.
it? If it's an exemption, it's an exemption.
I agree. Sorry, I was merely answering the.
Can we just look at it one more
does the
time?
judge deal with it? And I think the answer is no, he doesn't. The only reference to 8.5 he has is down in paragraph 84. As pointed out by the claimant, it remains open to the Secretary of State to amend section 8 to expand the list of conditions in 8.5. So here he's thinking about doing something completely different. And with respect, I mean, this is distinctly heading off piece.
So just so I understand the point, are you saying that when we get to, if you get to section 8 subsection 3 is clearly a discretionary power?
Yes.
On which you can impose conditions?
Yes.
Are you saying that if you get to section 8.4, so if you get to the position where the conditions in subsection 5 are satisfied,
yes,
you have to then grant an exemption under section 3, that is a reference to an exemption which is not subject to any conditions?
I think that it is not the case that you can't impose any conditions in relation to an 8.5 exemption.
But once you get to that point, if you don't impose conditions at all,
I don't think
does it matter what
I don't think
nature
the
of
Secretary of
conditions
State
are?
would maintain that it is impossible to impose any conditions under 8.5.
Okay, I'm sorry to be a nuisance. We keep talking about 8.5. It's not really 8.5. It's 8.4.
Yes,
Yeah.
I'm sorry. It does.
And that is quite important because 8.4 is where we look at the wording of.
Yes, that is entirely fair, my lord. I was sloppy. I've been referring to the criteria.
I think
in 8.5. You're right. It's 8.
Not saying you can't impose any conditions if you're within the section 8.4.
No, I don't think it's the Secretary of State's position is not that if all of the conditions in 8.5 are met and therefore a generalised exemption has, on basis of Ofcom's consideration, to be made by way of regulations, mean that there is no scope for any other sorts of conditions to be imposed. I don't think that is.
I think that you must be right about that because 8.4 talks about regulations under subsection 8.3, which means you roll the powers 8.3.
Yes.
Well, now I'm just, as one always says at these hearings, worried about time.
Yes.
You've carefully and profitably taken us through the statutory provisions, but that took us a long time. That's something obviously Mr. Segan won't have to do again. But so it's entirely understandable that you will have taken longer than he will have to in response.
Yeah.
Having said that, we can't allow you much time after lunch.
No.
Are you nearly there?
I think I'm probably going to be. If you can just think. Given that we have already canvassed, I imagine I can dispose of the remainder of it relatively quickly. But
See, I think we have. I mean, I don't promise not to ask you questions.
No.
It's very important.
Yes.
But I think
Most
we are now at the nub of it. Really, this is really what this case is about. Is the well, that's not entirely what it's about, but we're certainly at the central issues, and I think you're going to have to just think carefully about which of the points around the edges really are going to help us.
In relation to further material, and I completely understand that questions or not, I need to be done within half an hour of lunch.
Mr. Segan, that should be all right for you, shouldn't it?
I shall do my best and attempt to cut my cloth accordingly.
Yeah, well, we certainly don't want to be unfair to you, but I think the issues will be a good deal refined by 2:30, but you can't go beyond 2:30. And if you can do better than that, you will get the gratitude of the court. Very well, we'll sit again at 2.